And welcome back, everybody. We are now going to start with our last segment for the program with Henry Montag on essential life insurance trends, problems, and strategies for the attorney. Henry, you have the floor.
Thank you. What turn of truck did you fall off, Matt? I don't think so. Anyway, my name is Henry Montag. I'm a principal of the Tully Center East and an independent CFP practitioner since 1984. By the way, Tully Center stands for the Trust-Owned Life Insurance. I've written well over 100 articles, professional articles regarding life insurance issues, strategies, and I'd just like to thank the New York State Bar Association co-sponsors, the 50+ section, the Trust and Estate Law section, as well as the Committee on Continuing Legal Education, for the opportunity to provide what I'm going to call an executive summary of a book that I recently co-authored for the American Bar Association called The Advisors and Trustees Guide to Managing Risk. And let's talk about some of the things that we'll be speaking about. On the agenda, it's basically a matter of matching clients' objectives with policy design. We're talking about death benefits as well as living benefits. Also going to be talking about current problems in the life insurance industry. I'll be providing some case studies about that. I'll be talking about the death benefit for beneficiaries as well as case studies there. And lastly, we'll be talking about some of the living benefits of life insurance and talk about case studies as far as that goes as well. So this is not your life insurance that your father or grandfather might have been familiar with. We're talking about not only being able to provide maximum death, not only being able to provide death benefits for the beneficiaries, but also being able to provide living benefits for the insured. And then talking about being able to provide maximum death benefits using certain types of policies, as well as providing accumulation benefits using other types of policies. So starting off with why the life insurance is a problem, and recognizing that prior to 1980, it was basically, it was just, Carvel, it was whole life and term, and they made up 100% of the market. It wasn't until 1982 that E.F. Hutton, of all people, decided to get involved and create universal life insurance when interest rates were skyrocketing upwards of 13, 14, 15%. Many premiums were based on a 12%, 13% non-guaranteed interest rates, but when interest rates began decreasing, the billed premium from the insurance companies and the death benefits, they remained constant. And this resulted in a shortened duration of coverage. The owners, the trustees, should have increased the premiums, but they didn't know that they should have. It's a simple buy and hold philosophy as opposed to buy and manage. And as a result of that, we've seen nothing but reduced interest rates and neglect, providing a horror in terms of pieces of business that my office is seeing. Let me give you a case study. Individual age 55 purchased $1 million back in 1991. First question was, well, what interest shall we project? Back then, when interest rates were upwards of 12, 13, 14%, it was very popular for people to choose a 10 or 12% interest rate. Let's assume that we settled on 9%. So the cost for $1 million of life insurance to age 95, not guaranteed to 95, because there was no such thing as guaranteed back then, would have been $14,000. So in order to avoid the state taxes on $1 million, who should we have as the owner of the policy? Well, let's use my oldest son or my oldest daughter. Fine. Went out, took the application, had the son or the daughter sign it. Meanwhile, there's really never any mention of rate guarantees, nor duration of coverage, nor the fact that interest rates might change, or any sort of ongoing active management that would be required. Certainly no talks about trustee qualification or specialized knowledge, and the personal fiduciary liabilities and responsibilities of that trustee were not even a thought. So fast forward 30 years later, that 8 to 9% interest rate unfortunately wasn't achieved. The actual rate over the last 30 years was closer to 4.1%. And currently, that $14,000 premium will have that $1 million expire later this year at age 86. The premium needed today to cover that $1 million to age 95 is $26,000. The current premium, $14,000, instead of covering for $1 million, will only provide $450,000 of coverage to age 95. Again, this is the result of a buy and hold as opposed to a buy and manage. Non-guaranteed life insurance companies provide guaranteed policies today, but back then they only provided non-guaranteed policies. It's a good flexible product, but it doesn't come with any type of self-water management. What does the Wall Street Journal have to say about this? Well, I'll just paraphrase a quick moment, and just to say that the senior insurance sector recognized that people just aren't paying attention to life insurance. People are not familiar with it. The agents are gone. And this was a endorsement for the ABA book that I'd mentioned a few moments earlier. What are some of the concerns from the insurance industry? Well, Don Walters, general counsel for the IMSA, said, while insurers do not publicize the issue, there is a growing concern of the industry about lapsing universal life policies. Well, there should be. This is a typical annual statement, bottom of page 3 in a 6-page statement. And if you'll notice all the way on the bottom, it says important statement. And then an even smaller font, it talks about changes in interest rates may impact the insurance coverage. No, it might impact. It certainly does impact. Could the insurance industry have done a better job? Well, my observation is that yes, the insurance industry could have done and should have done a better job of communicating, 1, to their agents or brokers, and 2, to the general public. That last important statement is just, I had to put that up there because it's just so, it just rubbed me the wrong way so much. Agents should have been directed to service their clientele better. There should be new compensation agreements so that agents don't receive 100% of their commissions up front. They should be spread over to give the agent an incentive to be able to provide a service to their clientele to prevent this from happening. And aside from that, insurers, by the way, benefit. I've heard anywhere from 9 to 11% when insurance policies expire prematurely. So a trust-owned policy is a wonderful transfer mechanism. It's a sophisticated financial asset. It provides creditor protection management. It's ideally suited for trust ownership, but life insurance policies are not self-managing, and they can and they do lapse. Trust-owned life insurance, whether it's privately owned or whether it's trust-owned, the duration of that policy's coverage depends on the advisor's role. So let's take a look. The attorney does a great job gathering all the relevant data, reviews client intentions, discusses named beneficiary trustees, discusses the crummy provisions, and perhaps also discusses the trustee's role and duties. But that life insurance policy often doesn't talk about the need to monitor, doesn't talk about the need to review, nor actively manage the policies, doesn't talk about the fact that interest rates might change, and certainly doesn't necessarily talk about the trustee's personal fiduciary liability in the event that he or she is sued. Excuse me. CPA's role is very simple, focusing on the cash flow, focusing on preparing the crummy provisions. But again, it doesn't really get involved in the insurance matters, the adequacy of premium payments, ongoing reviews or performance evaluations. Along comes the private trustee's role in monitoring the trust-owned life insurance. And we're speaking of your clients' sons and daughters who have very little information, very little knowledge. They sign these life insurance papers, but they receive very little guidance. They file them away along with the annual statement, along with the policy. They're unaware of the monitoring responsibility, the fiduciary liability. They're unaware that they've assumed 100% of the performance risk. They certainly don't have the skills nor the abilities to properly review the insurance. They're not aware that premiums should be increased, and they're out of touch with what the grantors and the advisors often do. And here's an important part for many attorneys. Oftentimes the sons or daughters assume incorrectly, that the grantor's advisors or the grantor's attorneys are taking care of this, and that they're also providing the trustees with directions. You can ask yourselves when the last time was that you had a phone call from or to a trustee son or daughter asking for information or providing information to them regarding their life insurance. Good news, bad news. Good news about being asked to be the trustee. It's a statement of honor. It's an opportunity to manage trust assets and fiduciary responsibility to the families. But the bad news is that there is a high standard of performance, but they're often unaware of their liability and they don't possess the skills, and I don't want to overstep my boundaries in making fun of the fact that trustees are doing a job without any of the tools or help or guidance that they need. Now, the institutional trustees, by the way, the sons or daughters, the what I call the amateur or the unskilled trustees, they make up 90% of the ILETs. They make up 90% of the owners of policies, whether they're trust owned or whether they're individually owned. The other 10% are monitored and owned by institutional trustees. And due to the OCCs, the Office of the Control of the Currencies, their annual monitoring actually takes place. They fulfill their fiduciary duties simply because they're being monitored by the OCC. They minimize their liability exposure. They avoid any type of damage to their organization's reputations, and they're familiar with all the relevant responsibilities. And if they're not familiar, they know that they need to go out and obtain the necessary skills and contract for those skills. Why is the life insurance audit needed? To basically fill everything that I just mentioned, and most importantly, to prevent this. You're the advisor to an amateur trustee that calls to advise that he or she just received a letter from the insurer. Unless the premium increased from their policy of $2,100,000, unless the premium is increased, their death benefit will lapse next year. Insured is currently 82 years old and in average health. Currently, they're paying $29,000 in premium, but that's now insufficient. Premium should increase to $38,000, and that's to guarantee the policy only until age 95. What do they do now? They've already spent $580,000 in premium. What do they do? Hopefully, you should have an answer for them. If there's already a problem, the client should obtain, or someone should advise the client to obtain, an annual summary statement and actually read it. They should order a historic projection from the insurance company. If they don't know how to do this, or if they're not familiar with doing this on their own, they should certainly engage an independent broker to evaluate what the situation is. Client options are very simple. They can either reduce the face amount of the coverage, they can pay a higher premium. If they're healthy enough and if they qualify, they can obtain a guaranteed new contract, or if for whatever reason they can't afford or choose not to pay the premiums, they go ahead and sell the policy as a life settlement to an institutional investor or some combination of the above. Several questions that the trustee who's responsible for the policy should be asking themselves. Have you adopted a written plan? Have they updated and checked beneficiary designations? Have they regularly monitored the trust policies and premiums? Have you evaluated? The way that we do this in our office is through these 4 vehicles. Best way I know how to advocate for assets allocated to the next generation. And it's really a matter of advocating for that next generation, because I assure you, they are clueless. Everyone thinks about life insurance. They think it's going to be around forever. But unfortunately, a high percentage, an increasing percentage of the non-guaranteed life insurance policies issued before the early 2000s are coming to roost, and it's very ugly. What needs to be done? Standards for trustees. Restatement of trust laws adopted in most states establishes standards. They have to have a process in place to be able to manage all the trust assets, and that includes life insurance, not just the stocks or bonds, and not just the real estate. Life insurance is included. Trustees should obtain the grantor's guidance. What does the grantor want? What's the intent of the grantor? Not what was the intent 10, 15, or 20 years ago, but what are the intents today? What are the gifting guidelines? What are the preferences for restoring policy in the event that there's a problem? Someone's got to look at the insurance policy itself. They've got to verify the ratings of that company. They've got to recognize and realize that the policy performance might not be certainly is not what it was meant to be or what it was geared to be 15 or 20 years ago. Even with whole life policies with dividends, dividends are not guaranteed. And I remember years ago when dividends were upwards of double digits, 10, 11%. Today, virtually every dividend policy from all of the great mutual companies out there, they're just not doing what they thought that they might be doing. Aside from that, the cost of insurances, which is a license for the insurance industry to basically increase their premiums at will, has been a significant problem. Let's find out what the COIs have done, whether or not there have been any cost of increases, whether they have been there and how they've affected the individual policies. An adequate funding statement, this is certainly where the accountant comes into play to find out whether or not there's sufficient money, not just today to pay the premium, but whether there's sufficient money 10, 15 plus years from now to be able to avoid that future lawsuit. Take a look when it's done correctly. Individual, very simply, individual took out $1 million policy back in 2008. He was a smoker. Someone finally decided to have this individual take a look and see whether or not that policy could benefit from any reviews. We found out the individual was no longer a smoker. We're able to revamp with the existing company his existing policy, and instead of having a policy that was paying $24,000 and it was only going to be guaranteed till age 84, we're able to reduce the premium to $21,000 and, more importantly, increase the coverage to age 90. Another example, individual decided to leave a maximum inheritance to his grandchildren. Were you ever planning on using any of the cash value in the policy? No, I just wanted maximum death benefit. Well, we went ahead and took a look at the policy and found out that he had a whole life policy. And whole life policies, as you know, accumulate cash value. But he didn't want to accumulate the cash value. He wanted the maximum death benefit for the grandchildren. Very simply, he was fortunately a healthy individual. We were able to do a 1035, move the cash value from one policy into another. And for that same $16,000 premium, we were able to increase the coverage from $1 million to $2 million. Same premium, 100% increase in his coverage, just because somebody decided to take a look. An unfortunate example of an individual, male age 86, had a $1 million policy. Had an $800,000 policy, currently paying $26,000, zero cash value. Coverage was operating on vapors. Policy would have expired later that next year. The $29,000 premium would have only, an increase of basically $3,000, would only have kept his coverage in force for another year and a half. And then he'd be looking at 5% annual increases each and every year. Client was made aware that there's such a thing as a life settlement. Client agreed to explore it. We went ahead and we ordered a life expectancy report. Yes, you can do that. You can actually find out. This is one of Marty Schenkman's favorite tools. Find out what the guy not only looks like on the outside, but what he or she looks like on the inside. We found out that this client had a healthy life expectancy. The premium could not be afforded to be paid, or whatever reason the client decided didn't want to pay the premium. And we were able to obtain an offer for a life settlement and pay the client a $220,000 cash settlement. So we took a bill and basically took that bill and turned it into an asset. Unfortunately, when it's not done correctly, the list goes on and on. Some of these are well-known cases. If you have a process in place, the trustee can be saved. If you don't have a process in place, French versus Wachovia, then the problems deepen. Schneider versus Finman, personal representative of the estate, never had privity to or standing to sue the trustee's attorney. That changed. With Charles Parody, we found that there was a violation of trustee's duty. Trustee owes a beneficiary a significant duty, and there's a breach of trust, and the trustee again was sued. Brill versus Lincoln, were many individuals, because a life settlement is a way of pulling money out from the insurance company's pocket. as I mentioned earlier, anywhere from 9 to 11%. Individual was basically never informed that there was such a thing as a life settlement, and as a result, the beneficiaries sued the insurance company for the gag order that it placed on its agents to not allow them to disclose the fact that there was such a thing available as a life settlement. In Raffin and Meyer, a Supreme Court case, again, disregard for interest of the grantor and beneficiary. Trustee was punished severely. The Schneider versus Finding case, I'm just going to read the highlighted portion. The decision is going to change the whole dynamic between estate planning attorney and the executor after death, said Henry Leibowitz, senior counsel for Proskauer. These are serious issues. So how do we use life insurance in the current age? Well, certainly one way with the Secure Act, which removes the ability of keeping the distributions for going on forever. Have an example of a male 25 inherits $1 million. Normal life expectancy would have been 57 years. It would have had a taxable income of $17,482, and in the 24% tax bracket would have been approximately a $4,000 tax due. Under Secure, with the 10-year withdrawal, now would have to withdraw $100,000, 24% tax bracket, $24,000 tax due. It's an additional $20,000 per million. Individual has a $5 million policy. That's $1 million in additional future tax liability. Life insurance is a very good solution to pay that beneficiary's future tax liability. A good strategy might be to have a guaranteed universal policy which maximizes the death benefit, and to use a second to die because the tax due is not due until the second death. Using IRAs to pay taxes, well, I think that's probably one of what they call a death spiral. Not only is the IRA evaluation included within the estate for estate tax purposes, but the IRA withdrawals also trigger income taxes. Aside from that, as you know, the joke, the IRAs, 401s, 201s, they're certainly not guaranteed, and it's certainly dollar for dollar. A better alternative, if the income is not required, might be to use the future RMDs to be able to buy life insurance to pay for the estate taxes. I could just go on, but the point is that a second to die guaranteed universal life product does a very good job of paying the future tax liabilities, not only for the IRA, but for estate taxes as well. As Matt alluded to, certainly we very well may have estate taxes dropping down to a threshold of $3.5 million. Who knows what might happen with the step-up basis. Fact is that costs to pay the estate taxes will certainly increase for many people, and many people will be looking to their advisors to see how to deal with this. Again, in my opinion, a better way to pay for those increased estate taxes, again, is through the guaranteed universal life, which maximizes the death benefit, and using a second to die, which is less expensive. Guaranteed universal, it's a sufficient way to provide that coverage, and it's best used for the IRA beneficiaries' future income tax liabilities, as well as the future estate taxes on Iras and all other estate assets. Why use a second to die? Well, here's a great example. Individual $500,000 coverage for male age 78. Individual cost for him alone would be $31,000. Individual cost for female 74 is $18,000. However, the cost for a second to die for both would be $14,700. The MCLE verification code is S. MCLE verification code is S. Lastly, I'd like to talk about some of the living benefits of life insurance. And we'll be talking about the fact that an individual can today withdraw money from the death benefit of an insurance policy tax-free to pay for qualified long-term care expenses. Individual can withdraw money or use money to start with in a life insurance policy, not for the death benefit, as a SERP, a supplemental executive retirement plan, to be able to accumulate assets tax deferred, and then if it's set up properly, to be able to distribute those assets tax free. And by the way, they can do that on a totally discretionary basis. Lastly, as I mentioned a moment ago, as a life settlement, we can turn a bill into an asset. Let me just give a couple of quick examples. I still have, well, I'm going to be brief. Life insurance can be used to pay for various long-term care costs on a tax-free basis if it's set up properly. There are differences between a chronic care rider and a long-term care rider. I'm not going to get into the differences now, but there's some significant differences, and you should be aware of whether a policy contains a chronic care or a long-term care rider. Individuals can go ahead and use life insurance not for the death benefit, but for the living benefit. Example, male 45 deposits $25,000 to age 65 for that 20-year period. He will start out with $1.67 of death benefit. The income at age from age 67 to age 82 can be as much as $77,500. That's on a tax-free basis. And again, the death benefit must stay in force and must survive the insured for the tax-free distributions to remain in effect. Liquidating a life insurance premium as a life settlement to a institutional buyer is one of the best things that can be done. Example in this situation is male 82, had a $3.5 million policy, case that I just worked on, had cash value of $1.2 million. He wanted to provide a gift for his children while he was still alive rather than waiting. We were able to turn that $1.2 million cash value into a life settlement for $1.8 million, probably close to a 30-some-odd% return, a 30% increase. There's a lot more to be said, but I'd like to leave a little bit of room for questions for all the speakers. I'll speak for myself that I've thrown an awful lot of information out there, and for any clarifications, please feel free to email or call. I have the upcoming issue of Bloomberg's Trusts and Estates. The Estates, Gifts, and Trusts Journal has a article coming out over the next week, which I'll be more than happy to send anyone if they're interested. With that, Michaela, let me turn the floor back over to you for any questions.
Yes, we do have a couple of questions. One is geared specifically towards Cy, and it is, if the age for starting taking distributions is moved to 75, what happens for someone who is 73? Are they required to go on taking RMDs, or can they pause until they are 75?
Okay, the Secure 2 is going to have a pyramiding period. If you reach a certain age in this particular year, it goes to 73. Then 4 or 5 years, if you reach a certain age at a later date, then it goes to 74. And then if you reach another age way out, it goes to 75. So if you hit a certain age in a given year under the law, that's the age you're required to. So if they say, for example, in 2025, it's 73, and you hit 73 in 2025, you're locked into that. If you hit that, they're going to have a pyramiding deferral position in the Secure Act 2. You can look at Secure Act 2 online. You can see the dating of when these rules are going to come in. And it's a major, major piece of legislation. And it has a radical effect on Iras audits of RMDs that are taken. Statute of limitations references. It, in my opinion, will say if you miss an RMD, it's going to be an automatic penalty. You're going to have to get a waiver. It's going to put every accountant to, in a sense, be an IRS agent. And if they miss the boat and there's a penalty of either 10 or 25%, then there's going to be massive liability, whoever is handling that particular client's affairs, and the heirs that are being hurt by failing to comply with Secure Act 2.
All right. And we do have another question. I think this one's for you, Henry. They say, explain the comment that life insurance is not subject to estate taxes.
Well, life insurance, if it's owned outside of the individual's domain, if it's owned by another person, whether that person owns the policy individually or whether the person owns the policy as a trustee through a trust, the death benefit is excluded from the individual's estate. It's if you don't own it, you don't have to pay taxes on it.
All right, and those are the only questions that have come in. So if you all don't have any remaining words, then I'm just going to thank you all, Seymour, Matthew, and Henry. This was really great. This does conclude the seminar. So for all the attendees, please be sure to complete the course evaluation and return to your My Learning dashboard so you can enter in the verification codes for this program to receive your certificate. You may also print a copy of the verification form and submit it to registrar@nesbitt.org if you are not attesting through your dashboard. And thank you for choosing New York State Bar Association CLE programs.